Welcome back. My name is Rod Uphoff. I look around, I see many people were here this morning, but some of you are probably here for the first time. If you are and you missed the panel and Steve Bright's speech, that's too bad because I think you missed both a very entertaining and hopefully informative panel this morning and Steve Bright's presentation at 10:15 is something that hopefully you can watch on podcast because it also is something that you shouldn't miss. We're going to do our first panel of the afternoon with the five people that are seated to my left and to my right. To my left, in the middle, the distinguished-looking gentleman with the beard, Sean O'Brien, is from our sister school in Kansas City, UMKC, where he's a professor. There are, in the materials that you picked up, there are longer bios of each of the speakers, and I'm only going to give you the shortened version because each of the five people up here have achieved a lot over their legal career, and to get an idea of how distinguished they really are, you ought to just take a quick peek at those brochures. Sean's not only a professor at UMKC, he was a public defender for many years. He's one of the leading criminal defense lawyers in the state of Kansas, the state of Missouri, in the Kansas City area. He was the chief public defender in Kansas City. Sean, we're very happy to have you here. Going after Sean will be Kat Kelly to my immediate left. Kat is the deputy director of the Missouri State Public Defender. Prior to that, she was the training director of the Missouri State Public Defender, and before that, for many years, she was a line public defender in the Public Defender's Office. So she brings a wealth of experience both in the Missouri Public Defender system, but she's also been involved in training programs around the United States. And then to my far left, not politically but geographically, is Ron Wright. Ron is the Associate Dean of Academic Affairs for Wake Forest University. He was a trial attorney in the Justice Department. He's written extensively about the criminal justice system. He's also, among other things, on the VERA board, and that's a really terrific research institute that does a lot of creative stuff in the criminal justice system. So Ron, thank you for coming. To my far right, and I won't make any more political jokes, is Steve Hanlon. Steve is, among other things, a graduate of this law school. For those of you who are worried about jobs in this market right now, someday maybe you'll become a partner in Holland & Knight, which is, as many of you know, a very prestigious firm in Washington, D.C., and Steve manages their pro bono wing. So he does a lot of litigation around the country involving a whole host of different pro bono issues, but indigent defense is one of the areas that he and his firm focuses on, and he's been involved in much litigation, and he and his firm have won a number of awards for their tremendous pro bono work. So Steve not only is grounded in litigation around the country, but knows the Missouri scene very well. And next to Steve is, I'm drawing a blank. Sorry, Rich.
We've been close for a while.
We've been very close personal friends. Rich Rosen and I have been on a couple of panels together. Rich is from the University of North Carolina, where, despite the struggles of their basketball team,
it's a hard year to visit.
Yeah, well, it is. This is a really tough crowd. Rich runs, among other things, their Innocence Project there, and has been directly involved in a number of exonerations. He, like many of the people in this symposium, cut his teeth in the D.C. Public Defender's Office. So he is somebody who's written widely about the criminal justice system, is very familiar with issues of indigent defense, and he will be the commentator in this panel. So without me going on any longer, Sean, it is your podium.
Thank you, Rod. I have the unenviable task of not just addressing you after lunch when you're all full and a little bit sleepy, but coming right on the heels of Steve Bright and then in this distinguished panel of scholars and lawyers. I'm reminded of what comedian George Gobel once said. Did you ever get the feeling that the world is a tuxedo and you're a pair of brown shoes? That's how I feel right now. In the brochure, you're told that we're going to address some questions about the structure of a public defender system and what it should look like on the heels of this crisis. So I'm going to get that out of the way quickly so I can talk about what I want to talk about. So the answers are yes, yes, no, and I don't know. The Spangenberg report gives you a fairly bleak picture of the public defender system. He concludes in several places by saying that the caseload problem and the workload problem, the personnel problem, the salaries, the morale is so bad now that it is unlikely that there are lawyers in the public defender system who know what good representation is. That is a scathing indictment of the current system, of the status quo. And I want to tell you a couple of stories about the extent of the problem. When I left the public defender system in 1990, I became the director of the Missouri Capital Punishment Resource Center. One of the very first cases that I was called to provide representation in was a man named Ricky Lee Grubbs. He was on death row for a homicide that he committed along with his brother, and he was scheduled to be executed in 90 days. So I went to the prison. I met Ricky. We started investigating his case, and this is basically what we learned. He had had 2 trials. At his first trial, at which he was defended by a lawyer who would later become the director of a capital unit in St. Louis, resulted in a mistrial. Ricky testified in his defense, and the jury refused to find him guilty. The second trial, they decided to do something different. And at neither trial had they presented mitigating evidence. But in the second trial, they decided not to put Ricky on the stand because he would just be a target for the prosecution at this second trial. And the jury very quickly found him guilty and sentenced him to death. When we got involved in the case, he was scheduled to be executed on October 20th of 1992. And we started looking into his background for the very first time. We found that he had flunked the first grade twice. He flunked the third grade. He eventually dropped out of school in the 6th grade at the age of 16 and had been placed in special education and diagnosed as mentally retarded. We talked to the jurors in the first trial who told us they refused to convict Ricky because there had been a teacher on that jury. And the teacher, after hearing Ricky testify, went back and convinced the rest of the jurors, or not all of the rest of the jurors, that there was no way, because he's mentally retarded. I have had special ed students. I know what mental retardation looks like. This man is mentally retarded. There is no way that he could have the state of mind to be guilty of first-degree murder. And so that's why the first jury hung. Nobody ever knew that. Nobody ever knew that. And so we put together all of this evidence in October of 1992, thinking we could convince a federal court to grant habeas corpus relief or at least a stay of execution. And so we presented this. Here is a man who is mentally retarded. We got an affidavit from a 3rd grade teacher. We got an affidavit from the prison minister. We got an affidavit from prison guards. And we got affidavits from, we got school records, I mean the whole 9 yards in a very short amount of time. And our problem was that that previous summer the Supreme Court had decided a case called Coleman versus Thompson. And Coleman versus Thompson essentially says this: there is no right to counsel in post-conviction. And if you happen to have the misfortune of being appointed to be represented, or being appointed a lawyer who commits malpractice in the course of his representation in post-conviction, then you have no remedy for that. The language Justice Rehnquist used was, as between Roger Keith Coleman and the state of Virginia, it is Roger Coleman who bears the risk of attorney malpractice. And that was the rule that was applied to Ricky Grubbs, because his mental retardation was not presented at trial, was not presented on appeal or during state post-conviction, or even in his first habeas. He was procedurally barred from presenting mental retardation. And so we framed a certiorari question to the U.S. Supreme Court. And it was this: taking the Coleman versus Thompson holding and essentially saying, even for a prisoner with mental retardation, really you want that client to control the actions of the lawyer as if the lawyer is his agent who he controls his strategy and his investigation, his conduct? A retarded guy really, sort of, that's a paraphrase, but that was our third question, right? Really? We got a stay of execution. It was temporary from Justice Blackmun. Execution scheduled at midnight. At 5 minutes before midnight, we got a stay. And we're given until 8 a.m. to brief that question for the U.S. Supreme Court. So he faxed the brief in. The Attorney General gets until 2 p.m. to respond. And then we get until 5 p.m. to file a reply, while Ricky is in the death watch cell with the gurney right outside the door. Along about 8 o'clock at night, we get a call from Chris Bassel, the clerk of the Supreme Court, who says, court's not going to grant cert on your issue. Of course, John Ashcroft is our clemency failsafe, right? And he's already told us no. So Chris, being the gentleman that he is, gave me a 15-minute head start that I could talk to Ricky and tell him that appeals are over and you're going to be executed in about half an hour. So I got to make that phone call. And, you know, he's mentally retarded, he says. I said, Ricky, they're denying your case. And, you know, when you represent somebody on death row, you just don't come right out and say they're going to kill you, you know. You find a way to couch it so that they know, so you don't have to talk about it. It's kind of like being an undertaker. So I said, well, you know, Ricky, that's it. Appeals are over. He says, what about my certiorari? You know, he couldn't pronounce certiorari. I said, well, that was it. It's over. Okay, well, what's our next appeal? You know, he doesn't know. He doesn't understand the court system. And I say, well, Ricky, there is no next appeal. Well, what are you trying to tell me? Well, Ricky, they're going to execute you. And they came to the cell, the death watch cell, and they took him away and they strapped him to the gurney before I could make it to the prison. And when I got there, he was dead. That's what substandard legal representation gets you in these cases. That was my first experience as a resource center lawyer with a client under a sentence of death. Since then, my next case was a guy named Bobby Shaw. His public defender made a 1/2 page closing argument in the penalty stage of his trial. And the central theme was this. I remember it word for word. His passionate plea for his client's life. He told the jury, why sully your hands with this piece of flotsam on the sea of humanity? Not surprisingly, the jury was not persuaded by an argument that analogized his client to a piece of trash. They voted to execute Bobby Shaw. And fortunately, I'd learned enough in the representation of Ricky Grubbs to keep him alive long enough for Mel Carnahan to become governor and commute the sentence of this man who had schizophrenia and mental retardation that the jury that sentenced him to die never heard about. Those were early cases. And the public defender system has incrementally improved since then. And now I'm working on cases with the Midwestern Innocence Project, and I'm seeing some of the same stuff. The case I'm working on now, kind of like bookends on this post-conviction career, is a man named Ricky Kidd who was defended by a public defender who was an experienced public defender. This is a first-degree murder case. So she's one of the more experienced defenders in the Jackson County office. And it's a one-witness ID case. No physical evidence linking Ricky to the crime. Fingerprints are there, they're not his. Footprints are there in the blood, they're not his. And the trial defender did not know the basic rules of evidence for impeaching an ID witness with a prior inconsistent statement. There are inconsistent statements all over the place, and not a single one makes it to the jury. And 3 times the trial judge says, don't you know how to impeach a witness? And on this lawyer's resume, she is a trainer who trains other defenders on how to try cases. Holy crap. So now at this point, as we're digging through the case, we've talked to the co-defendant who has given us a complete confession. and naming the actual co-perpetrators of the crime. We've got an independent ID witness who identified the actual perpetrators, and we're absolutely convinced that this man is innocent. And we're running afoul, again, of what? Coleman versus Thompson. Coleman versus Thompson is still, as Steve was saying, the justice system flat doesn't care about these cases. So, now, here we are. In the last 20 years, we've had 17 people, actually 18, because I left one off of that footnote 13 in my article, who have been exonerated. Almost all of those defended by public defenders. The public defender system involved in only 2 of those exonerations. Prosecuting criminal defendants in Missouri is like shooting fish in a barrel, as Warren Buffett says, after we've let the water out. Many of Missouri's 66 executions are just like the ones that I've described. How do you put, and that's the challenge for all these panelists, when a system is sunk that low, how do you fix it? How do you begin to repair a system where the basic fundamentals of criminal defense are not understood by your most experienced lawyers who are on the front lines of handling cases? Now, don't get me wrong. I did not intend for this to be or even sound like a diatribe against public defenders. I love public defenders. My heart is always with the public defender system. And the people in the room, Nancy McCarroll, my God, I've got at least, I can think of several clients who would be dead, but for the valiant work that Nancy, Melinda Pendergraft, I saw her earlier, I don't know if Melinda's still here or not, who have saved men literally from the jaws of death. And so my suggestions, just very briefly, about what we need to do politically. One issue that I think has the potential to save the Missouri defender system is pushing the concept of parity. Equal resources between the prosecution and the defense. It has been in place in the federal defender system since the 1990s, so that since the concept of parity has been endorsed by statute in some cases, Connecticut, the public defenders and the prosecutors go arm in arm to the legislature and say, this is what we need for salaries. There are some jurisdictions in Missouri where prosecutors would probably get salary increases from the concept of parity, but by and large, mostly it will be public defenders who would benefit from that notion, that there be parity not just in salaries, but in workloads and in resources, investigators. And it has been something that in systems that have embraced the concept of parity, it has stabilized staffs. Attorneys can actually have careers in public defender offices where they work for 20 or 30 years and then retire. The quality of representation is good. The federal defender system is a good example. James McKay wrote a letter to the Missouri Bar Journal after having left Missouri and gone to Connecticut, where they have parity, and explaining how a balanced adversarial system produces more reliable results. And the American Bar Association endorses it, that if the prosecution is adequately funded, then the public defender will be too. It's the imbalance in the public defender system that creates some of the problems. A good example, Nancy and I were doing a hearing on a fellow named Stevie Parkus, who is mentally retarded. And we're struggling for public defender resources, and she's helping me. And without the involvement of her in the office, we would not have been able to muster our own witnesses. But they brought in this psychiatrist named Wade Meyer, who, how many of you seen the movie Monster? With Charlize Theron, Eileen Wuornos. Dr. Meyer said Eileen Wuornos was sane. There's nothing wrong with her, so that she could be executed based on his testimony. Big gun. They brought out the big guns for little Stevie. Here's a guy who has been diagnosed as mentally retarded since childhood. This guy charges $6,000 a day to come in and give his opinions on behalf of the prosecution and basically hand them what they want. He's, the psychiatric version of prostitute. And, you know, you can see the Attorney General, the one moment in that hearing that sticks with me, and Nancy, she'll alibi me that I am not lying about this. When Dr. Meyer, we asked him on cross-examination, I want you to just look at our, he thinks he can kind of eyeball him and say, no, he's not retarded. Okay, where do you think his intellectual functioning is? Where would you put it? There's this long pause, this long, long pause. And he says, finally, well, I might put him somewhere between average and above average. And the two guards, you remember this, the two guards who escorted Steve to the hearing laughed out loud. So much for your $6,000 a day expert. You know, these corrections officers just pulled the rug right out from under him. And thanks to Nancy's work, you know, we finally got Steve off of death row under Atkins versus Virginia. And so, you know, parity. You know, you can't count on those guards every time. Would have been nice to have our own $6,000 a day expert. The other aspect of the defender system that I would change is to bring private lawyers back into the system. Right now, all conflicts are done in-house. And even allegations of ineffective assistance of counsel against public defenders are all done in-house. And I can't help but think that there are systemic conflicts that come from that. Other systemic conflicts that I see are that public defenders now make the determination of indigence. If I find you indigent, you're getting added to my caseload, which is already too high. Do you perceive a conflict of interest there? And I was down in the Jackson County office about 2 months ago to visit a friend down there, and I rode up on the elevator with a couple of young defenders. I don't know who they are, they don't know who I am, but I was listening. Yeah, people talk on elevators about just the most wild stuff, like nobody else is there. You know, I was like, I don't know what the deal was. But they were very proud of themselves about having won a hearing at which they were resisting appointment in a case, as if they won. And it just broke my heart to hear that conversation. The client was the enemy. The client was the enemy in that situation. And honestly, it just broke my heart. In the Joe Amrine case, after we got the Missouri Supreme Court to declare him innocent by clear and convincing evidence, we tried to get appointed to do the retrial. In the defender system, I think some of the things we might have said in the course of representing Joe over the 7 years before we got the Missouri Supreme Court to make that declaration, I think I pissed somebody off. But they wouldn't agree to appoint us to represent him. They were concerned about the costs. I'm not sure what they were concerned about, but we actually, in order to stay on that case, got funding from the European Union, who agreed to pay for DNA testing and whatever we need. And finally, the prosecution dismissed the case after the DNA broke our way. And that was a difficult issue. The system is designed so that only public defenders provide representation, and only those lawyers who are willing to work for the contract rates are eligible to represent people where there are conflict of interest cases. And so what we've done is we have excluded the input and the participation of the vast majority of the mainstream bar from our indigent defense system, and that's a real problem. The other thing that we have done is we have created a subclass of lawyers in Missouri. Public defenders, while they're valiant people, they work long hours. I love them to death. Their heart is in the right place. They have become the whipping boys of the Missouri criminal justice system. Whipping boys and whipping girls. You know the analogy in the British monarchy, another weird institution besides our indigent defense system. It was unseemly to lay your hands on a member of royalty, so you had a whipping boy was the guy who, another boy, if the prince misbehaved, you clobbered the hell out of the whipping boy to teach the prince a lesson. And that's the role that I think public defenders play in our current justice system. I've heard different defenders' offices referred to as the Nike team. Just do it. And so the Missouri Supreme Court in 1971 urged the legislature to fix the problem because the bar cannot carry this burden alone. And the response to that has been to take that burden and compress it and confine it among a subgroup of the Missouri bar, which is public defenders. And God knows if the whole bar can't do it alone, the public defender system can't do it alone. And so our response, whatever it is, has got to be to spread the burden and the duty and the obligation, the privilege of representing people who are targets of the government to take away their civil liberties, their freedom, and their very right to life. That burden belongs to all of us. Thank you.
Steve Bright, during his talk this morning, had his PowerPoint up with the lawyer asking, how much justice can you afford? In Missouri, if you are a public defender, that's $288 if you're in trial with it. That's what we spent as a state last year. An average cost per case was $288 for cases within our trial division. If you add in capital and appellate cases, it came out to an average cost per case of $355 per case, slightly more than $300 worth of justice that you could get in those cases. Last year, Missouri public defenders handled a little over 83,000 cases in 115 counties. They drove over 2 million miles to do it. This morning they were talking about, Norm Lestine was talking about the NAC standards, the National Advisory Council caseload standards, as being absurd in terms of they were absurdly too high. For us to reach those standards, we need another 170 lawyers within our trial division and another 21 lawyers in our appellate division. So for us, that's a pie-in-the-sky goal, as opposed to absurdly too high. It's all, unfortunately, a sad matter of perspective. So what have we been doing about it? Well, in 2004, when our caseloads hit, at that point, about 89,000 was our top in 2004. We've actually crept down a little bit. We were at a Missouri Bar gathering. They do an awards dinner every year that recognizes a defender of distinction. And the truth be told, that pretty much was the sum interaction between the Missouri public defender system and the Missouri Bar at that point. We were a completely self-contained system, and were not at all actively involved with the bar. And we sat and listened to one of the speakers. That was the year of the big initiative that the bar had done on behalf of legal services, increasing some funding mechanisms for legal services. And one of the speakers made the comment about, a number of years ago, back when the state public defender system was created, we fixed the public defender system, and now we've done the same for legal services. And those of us that were in the room retreated to the bar afterwards and were venting a bit about that we didn't feel exactly fixed. And eventually, sort of this unsettling truth began to worm its way into our discussion, which was, well, how really would they know that we are in this mess? Because the truth of the matter was, we weren't involved with the bar. We weren't having conversations with them. We went every year to the legislature, and we made our presentations to the committee, but the bar isn't present at legislative budget hearings, and there's no news coverage of our issues. And so we had to accept some responsibility for the fact that we weren't being rallied around to try to help us fix this problem. And so our director, J. Marty Robinson, who sends his regrets he can't be here today, he's on military duty in Pennsylvania, I believe, this week, he set up a meeting with the then new bar president, Joe Whistler, and Doug Copeland, who was the incoming bar president, met with him as well, and laid out, this is where we are, this is what we're dealing with, we've got to have some help. And lo and behold, they weren't at all as oblivious to our concerns as we had given them credit for. They actually stepped up, and they appointed a task force on the public defender that Doug Copeland chaired. He brought together a broad group of legislators, judges, prosecutors, folks from the Attorney General's office, private bar leaders, and the group began to find out what was going on with the public defender system. They're the ones that got the funding for that first Vandenberg study, and they are the ones that began saying, we've got to at least get some initial money into the system while we work on a longer project, and began to work toward a $2 million increase for salaries for our lawyers that year. because at that point we were looking at, over the previous 4 or 5 years, the equivalent of 100% turnover in our attorney division. So that was the first step. One of the things that, once we began to engage the bar, we also found we had an avenue for engaging the media. Because the Missouri Bar does media tour every year with one of their big issues. And they took us that year as their primary issue on that media tour. They set up lunches and breakfasts all over the state with local media. The Missouri Bar president was there. On some, the Chief Justice was there. And we talked to all of these reporters, print, TV, radio, about our caseload crisis. And the number of articles on the public defender caseload crisis exploded all over the state. It was eye-opening to us at the reaction that we began to get. We began to see editorials that this is a crisis, that the public defender system needs resources. We have to do something about it. And once we were on the media radar, that has continued. You know, we have had to do some sort of readjustments because the media generally wants the local story as well. You know, they want to hear the big picture, but then they want to know what the story is in their local office. They want to do the day in the life of the public defender. And most public defenders, when the media calls, our response is no comment, and we're done. So we had to do sort of a re-education among ourselves in terms of dealing with the media and working with the media and getting that story out. And so many of our lawyers, some of who are here, I call on a regular basis and say, hey, can I send a reporter to follow you around or to interview your clients? And they put up with it, perhaps grudgingly, but they do put up with it because it is critical that the public at large know what we're dealing with if anything is going to change. And some things have changed. I will be the first to admit we are not anywhere close to where we need to be. But the conversation has changed and the direction has changed. We are beginning to make some progress. Not as fast as any of us would like, but some things have changed. One of the things that we found is when the media began to notice, when we would go talk to the legislature, we got a different reception. Because all of a sudden, we were on the radar of the folks back home. And as we began to talk with them about just what we were dealing with and all of the impacts on that, we were in fact able to convince the legislature that this is not a left-wing, bleeding heart liberal issue. Justice is a bipartisan issue. It really is. And it became that in the conversations that we had with the legislature. I remember one of the first meetings we had with then President Pro Tem of the Senate, Mike Gibbons. We have a Republican legislature in Missouri, and at this right now, a Democratic governor. So he was a Republican, and we met with him in his office. He's a lawyer. Under his conference table and under the glass was the Constitution. And so we sat down for this first meeting, and I'm like, there we are, right there. You see the Sixth Amendment, right there. And he said, well, you know, it's true that not a lot of what we do in state government is constitutionally mandated, but you are one of them. And he appointed an interim committee, a Senate interim committee on the public defender that was chaired by a former prosecuting attorney, Senator Jack Goodman out of Southwest Missouri. They held several hearings over the course of, while the legislature was out of session, issued a report confirming what the Spanshenberg report had found, that there is a crisis in the public defender system, making a number of recommendations of things that need to be done. And for the next 3 years, he sponsored legislation trying to bring some caseload relief to the public defender system. Finding out everything takes 3 years at least to get beyond that. That's been a long haul as well, and an education process for me in working with the legislature. But this past year, Senate Bill 37 was the final incarnation of that legislation, did pass the legislature unanimously in the Senate. 134, I believe, or 139 to 16 in the House. And it was really fascinating to me to listen to the debate on that day because Representative Don Callaway, who was a Democratic representative from St. Louis, stood up to speak in behalf of the legislation. And he said, you know, you will probably not find another piece of legislation this year that I will be in agreement with the sponsor and the bill handler, because the sponsor is one of the most conservative Republicans we have. The bill handler in the House is one of the most conservative ones we have, both former prosecutors. You're not going to find anybody more left-wing liberal than I am, former defense attorney, and yet on this issue we stand together because justice is not a bipartisan issue. They passed the bill. The governor vetoed the bill. But in doing so, the governor did say, correctly, I believe, this is not going to fix the problem. none of us thought it would fix the problem. There are two issues, and we have to keep those separate as we look at what the situation is here. There is the issue of the caseload crisis within the Missouri public defender system, and there is the indigent defense crisis within the state of Missouri. And you can fix the one without fixing the other. And that is essentially where we are right now. We are in the process of offloading cases to take care of our lawyers, and so they can provide effective representation to the clients we bring into the system. But those folks who are offloaded are still out there without lawyers. And that is the challenge that still has to be fixed, obviously, in the system. So let me talk a little bit about where we are today. The Supreme Court, in addition to the legislation that was vetoed, there was also the Public Defender Commission enacted an administrative rule that had done many of the same things, that set maximum caseload caps, maximum capacity for each office. And under the rule, if they have exceeded that maximum for 3 months in a row, 3 consecutive months, that office could be placed on limited availability. If an office was placed on limited availability, we would identify categories of cases, the less serious cases, although I agree, as Steve says, there are no small cases in the criminal justice system, if it's yours especially. But we basically would identify those less serious cases of misdemeanors, traffic cases, perhaps probation revocation cases where someone had already been sentenced, and tell the court, we're not going to take those cases anymore. We will only take the felonies or the more serious misdemeanor cases. That's the way the rule was originally written. And we began under that process certifying offices that were overloaded, and that was, I think, at that time all but 3, saying we're going to have to turn cases away. We had different reactions in different areas. In Southwest Missouri and Greene County, we got a lot of cooperation from the courts, from the local bar. The Springfield Metropolitan Bar Association put together a volunteer group of attorneys, about 80 attorneys on that list, that stepped forward to begin taking those probation revocation cases that we couldn't handle. The prosecuting attorney there began to divert a lot of the minor property crimes and cases that could be resolved without jail time, so that those didn't have to come to the public defender plate. So we had some cooperation there, and the capacity, the overload in that office began to decrease some. In other areas, we didn't get quite that cooperation. Here in Columbia, we had judges, as you've heard already this morning, say, we're not buying that rule, we're going to go ahead and appoint you anyway, we don't think the commission has that authority. And so that went up on a writ eventually to the Missouri Supreme Court, which issued a case in December, a ruling in December, that says basically the Public Defender Commission can't exclude categories of cases. You can't triage your cases. You can have your doors open or you can have your doors closed. But you can't pick among the cases that you're going to let come in, which is what the rule tried to do. The reason the rule tried to do that is because what has been happening is the lawyers have been forced to triage their cases within their caseload. They're having to be the ones to pick and choose between which ones are going to get their time. So our goal was to try to move that at least out to the doorway, so they weren't the ones putting their licenses on the line, being liable for malpractice, while those clients weren't getting effective representation. And if we couldn't take care of everybody, let's at least take care of the ones facing the most serious consequences. But what the Supreme Court said is, under the statute, you don't have that authority to pick and choose. Your doors are open, or if you have too many cases, your doors are closed. And they encouraged what the rule had already encompassed, which is a time of discussion with the court, of sitting down with the court and the prosecutor after you've given them notice that this office is overloaded, we're going to have to turn away cases, to see if they can triage our cases for us. Because the prosecutor can triage cases for us by choosing not to seek jail time. Then there's no constitutional right to a lawyer. If the judge wants to triage the cases by either appointing private counsel or by dismissing the case, that's something that the judge can do. So that's where we are right now. That ruling became final on December 24th, our caseload cap Christmas gift. And we began then in January sending out notices of impending certification, and we've done that at this point to 8 offices, which covers about 13 circuits would be impacted. And it's not that those are the only ones that are overloaded. We started with the most overloaded. Again, I think at this point we maybe have 5 offices or so that are hovering right at maximum, but the others are all overloaded to varying degrees. So we are in the process of figuring out what can be done informally to keep us from having to close our doors. And once again, we're getting mixed receptions. And some offices that I have met with, everybody's saying, okay, we've got to fix this. The judge is saying, I'm going to appoint private counsel to juvenile cases. The prosecutor's saying, I won't seek jail time on any misdemeanors unless it's, an assault case of some kind. So there are some where they're saying, okay, we're going to do this. Others are less than cooperative, shall we say. And some, so far, have not managed to meet with us at all. So I think it is a matter of time, without any doubt, before doors are closed somewhere. And the question then is, what happens at that point? But where we go forward, one of my big concerns is that we not institutionalize this as a fix. Because even those cases where the prosecutor says, okay, I'm not going to seek jail time, what is happening in many, many areas that we're seeing is the court's getting a waiver of counsel for them. So they can put them on probation rather than just sentence them to a fine because they want some time, so usually they can make restitution or whatever. Well, once they've signed that waiver of counsel form, the protections that they can't be sentenced to jail if they're revoked are gone. And so we're seeing the erosion of at least the expectation that counsel is required in these cases. So that's why I want to highlight fixing us is one piece of the pie. Fixing the justice system and the whole issue of indigent defense is a much larger piece that has yet to be addressed. So, and I'm out of time. So.
Good afternoon, everybody. I'm going to talk to you about something that started off as just a head-slapping curiosity. Who would have thought that public defenders are elected in some places? Huh, how weird, and then maybe you just move on. But the more I think about it, the more I think it's more than just a head-slapping curiosity, that it really is something revealing. It's not so much revealing in those very few jurisdictions that do elect their public defenders, but I think it's useful to think about why we don't do it much anywhere else. I think that tells us something about the kind of public control that we think appropriate in a criminal justice system in a democracy. And this is one of these places, criminal justice, where we spend a lot of money, the public's money, and we apply core public values. And in a democracy, we very often resolve these things with various kinds of accountability, including elections. But why does this strike me, anyway, as just a head-slapping, wow, that's just weird. So I want to talk about my thought process that I think some people might share here. I think it's also important to think about this in terms of incentives. If you're thinking about how do you change an office, how does it do better work, very often you ask, well, how did the person in charge get his or her job, and how are they going to lose their job? That's just sort of simple economic analysis of institutions, and So you want to think about who are the public defenders answering to. If you think about it, we elect 2 of the 3 major courtroom actors. So in every jurisdiction, well, not in every, in 46 of the 50 states, we elect prosecutors at the local level, and that's relatively uncontroversial. We sometimes elect judges, as I mentioned. I talk about this at the home of the Missouri plan, but we have attenuated forms of judicial election. So over half of the judges, well over half of the judges face the voters at some point or another. Or law enforcement. You think about this. We don't elect that many police chiefs, but we elect almost all the sheriffs. So big chunk of law enforcement is elected. When it comes to the public defenders, almost never. Except, it turns out, in 2 states plus parts of a couple of others. So we elect public defenders throughout the state of Tennessee, throughout the state of Florida, in jurisdictions over 100,000 population in Nebraska, which I think is Lincoln, and then a few places in California. I know of San Francisco. So we do have these handful of places where we actually elect the public defender. I want to describe to you how prosecutor elections happen, because I want to be able to compare that to what happens with public defenders. I've done a little bit of work on the election with prosecutors, and the story for me here is that incumbents almost always win and almost never have to explain themselves to the public. So if you look at the numbers here, just a sort of random sampling of prosecutor elections over the past roughly 10 years in 12 different states from all around the country, you see that the incumbent runs, roughly 3/4 of the time. One of the key facts here is highlighted in the middle. The incumbent is almost always unopposed. So an incumbent prosecutor, if they run, they're going to be unopposed 85% of the time when they actually compare that to what happens with state legislators. Same basic electorate, same local level electorate. State legislative candidates or incumbents run unopposed only 35% of the time. So, a major difference there. You also start to get some difference as you get larger jurisdictions for the prosecutors. So there, only 55% of the prosecutors run unopposed if they're in a big place. You just got a bigger pool to draw from. More people are willing to take on the incumbent prosecutor. What's kind of interesting to me is if you look at these elections of public defenders, the outcomes of the elections look more or less the same. So the second column over here are the combined results from about 10 years worth of elections in Florida and Tennessee. And you notice that in the key category there, incumbent unopposed, the incumbent, even for public defender offices, is normally running unopposed. 83% of their races, they're running unopposed. If they actually run, they're going to win 98% of the time. So it's not as if there's a lot of turnover. Everybody, you could think of it as a race to the bottom. Every time around, a new candidate promises less for public defense, and they keep winning. It doesn't actually play out that way, and so part of the curiosity here is why. Why doesn't it turn out that way? For me, one of the more disturbing, or the reason I think of the second row or the third row is disturbing, unopposed races. For the prosecutors, if you're unopposed, you don't have to explain your office priorities. Nobody's there to provoke you to say, here's what I've been doing, here's why I'm doing it this way, here's why I think this is in line with public values on this is why I emphasize this kind of case versus that kind of case. You never have to say that if there's not an opponent out there kind of taking pot shots at you. What do the prosecutors talk about when they are pushed into a campaign, when there is some challenger to the incumbent? What do they talk about? They tend to talk about specific cases. I went into this thinking they're going to talk about their conviction rate. They're always going to say, you know, I get 95% of my cases. Turns out they don't talk about that nearly as often as other things. They mention it, but what they really talk about is last year's big case. That murder case that was in the news all of last year, and you read about it in the paper all the time. That gets mentioned all the time. Or last year's indictment against a city councilman, or you know, whatever the big heater case was in the news in that jurisdiction. The incumbent candidate and the challenger talk all the time about the single cases that captured the public imagination. They talk an awful lot about personal integrity, and so they talk not only about their legal experience and what they can do in the courtroom, but also their, you know, they frame things in terms of character, and you get lots of accusations going back and forth about indications of lack of character. As I mentioned, the conviction rate is a minor theme, and overall the prosecutors are talking about cases rather than policies. What was surprising to me is it's a bit different when you go out on the campaign trail with the public defenders. So with the public defenders, you do often hear the incumbents talking about efficiency. I promise if I'm elected that I will make good use of taxpayer resources. I will get you good value for your money. They typically don't go beyond that and say, you know, I'm going to let the caseload rise on all my defenders so that that's a way of getting efficiency. Occasionally you will hear people talk about office policy as to which cases they're going to take. And so they say, we need to triage, and we are going to enforce our indigency requirements a bit more rigorously, or we're going to be a little bit more aggressive about seeking recoupment of fees after the fact from clients. Once or twice you see incumbents say, you know, my strategy is always to encourage people to come in here, get out the door in a hurry so that I can hire somebody cheap to replace them. You know, keep the salary scale kind of low. So that's not a terribly encouraging theme, but once or twice that showed up on the campaign trail. But then you also see a few cases where the candidates talk about tactics in particular cases, not just office policies. So occasionally you'll see the candidates say, you know, you need to shake things up in the office because I believe this public defender has too cozy a relationship with the judges or with the prosecutor, or too adversarial relationship, but we need to change the dynamic of the relationship. For me, one of the more disturbing examples of a campaign theme is brought to us by Mr. Shirk here, a challenger to the longtime incumbent in Jacksonville, who promised on the campaign trail, if I am elected, I promise you that no attorney who works in my office will ever accuse a police officer of lying. The Fraternal Order of Police contributed to the campaign. I don't know that they made a formal endorsement, but they were happy about this. Noises started being made about bringing bar ethics charges against Mr. Shirk for anticipatory malpractice. And so he backed off of that theme a bit. But this is, for me, the single most disturbing story as you read through the campaign, you know, the accounts of what happens in the campaigns. Well, how might you respond to this? You know, some people might respond to this and say, you know, the problem isn't that it's just PDs being elected. It's election of any criminal justice officials at all. We really shouldn't elect any of these folks. It should be all by appointment and just keep the voters out of it. And it's certainly a legitimate position. It's an important sort of pole in our debate about the level of proper democratic control in this system as we have in lots of different public services. If you take this view, I think you have a certain set of views about voter capacity. So I think you might have the view that there are a lot of the choices being made here are really empirical, almost scientific kinds of facts. You know, you may as well poll the public on whether the earth is round or flat as ask, you know, who's an appropriate public defender or appropriate prosecutor. There's also, I think, something of a view built into this perspective that voters are particularly irrational when it comes to crime. And there's, you know, some real evidence you can point to on this. But, you know, if you're willing to trust voters for certain things, why not crime? I think part of the answer is we believe that voters just react more viscerally and more irrationally crime into other settings. I tend to think that didn't quite capture the truth of it, but I end up on the other end of the pole of this in terms of a proper public involvement in control of criminal justice. You see examples of this in other parts of the world, of course. If you go to other countries, the prosecutors are not elected, they are appointed, and they join a bureaucracy early in their careers, and they work their way up the scale. There are places where we elect none of them, where all the criminal justice officials are not elected. You might go to the other extreme of the spectrum here, and you might say, well, really, we should elect them all. This is a democracy. These are major parts of the budget for state government. We are applying core public values here. If you're going to elect anybody, you really ought to elect the people who are administering this critical system for the public. You might point out that the public is already very heavily involved in regulating criminal justice. The public ultimately sets the budget through legislatures. They control which defenses are available to public defenders, which crimes are available for the prosecutor to charge. There's really no question that the public ultimately controls the shape of the criminal code. So there are all kinds of other examples of the public being directly involved in the tools that are available to the people who run the system. Why not have some input on who the people are who are using those tools that the public makes available? So I think there are all of those things to be said in favor of a position that says elect them all. We have lots of public control in there anyway. There's really nothing illegitimate about the public being involved in the direction of the criminal justice system. We do this in a lot of settings. I know in my home state we elect the insurance commissioner, and we elect lots of different administrators of fairly technical systems that nevertheless affect the voters, affect their pocketbook and public morality. So we have some examples of doing this. Nevertheless, I try to take a position here that I think it's appropriate to elect the prosecutors, not the PDs. As for what vision of the voters you might have if you take this position, I think you have the vision that the voters are educable, that voters might have an initial response that might not be appropriate, but voters are educable in this area as in many other areas, so an initial reaction might be irrational, but later on you can bring around more measured responses from the electorate. Nevertheless, for public defenders, the problem is that the public defender has a different principle, is an agent for a different principle, PAL principle, than the prosecutor or the judge. The prosecutor and the judge are there on behalf of the public. The prosecutors the public defenders serve public purposes. They are hired on behalf of the public for good reasons, but they are the attorney for a client. And so the equivalent here would be, for instance, under Model Rules of Professional Responsibility, Model Rule 5.4, that says if somebody else is paying you, you have to remind them, look, you're paying me, but I am loyal to the client. I have to do what's good for the client, not what's good for you as the person paying me. I think the analogy to the public paying the public defenders is quite appropriate here. Whereas with the prosecutor, I think there's a lot more to be said for the prosecutor responding to the priorities of the public in selecting cases and picking one category of cases rather than another for prosecution. In the long run, this is. I have one other point about this. I think one other reason that we can appropriately elect prosecutors but not public defenders is what are our alternatives? When it comes to prosecutors, we don't have many alternatives to voter control. We write these huge criminal codes that have all kinds of charging options in them, very broad, very deep charging options in the criminal codes. And we don't do much in the way of telling the prosecutor, you've got to choose the one at the top of the scale or the one that's typical in the middle of the scale. When we turn to judges and say, judges, can you creates some form of accountability for the prosecutor in picking the charges. Judges routinely, and I think in my mind appropriately, say, I'm staying out of that. I will not get involved in second-guessing the charging decisions of the prosecutor. So, for better or for worse, we don't have a lot of alternative methods of controlling the prosecutor. We depend on the good sense and judgment of the prosecutor, but ultimately we also say, since we don't have alternative methods of control, you got to send them to the voters. On the other hand, with the public defenders, we've got all kinds of other alternative methods of control. So we've got the criminal code itself that provides very limited defenses, very limited methods of establishing some ground for an acquittal. We've got, as we've talked about today, very limited budgets for the public defenders. There are plenty of ways that judges can control the output of the public defender's office, because you can't just say this ought to be dismissed. You've got to go to the judge and get somebody else to sign off on it. There are all kinds of other people who are there to collaborate with, or to check, or to be in somehow deciding in conjunction with the public defender. So unlike the prosecutor, who very often can act alone, the public defender virtually never acts alone. So in that setting, I would suggest to you that we don't need the voters, because we treat the voters, I think, as the control of last resort, the form of accountability of last resort. And for that reason, I think it makes some sense that we've reached a world where 46 out of 50 jurisdictions elect their prosecutors at the local level. Even the others elect their prosecutor at the state level. And 48 out of 50 states don't elect their public defenders. I think there's some reason we've ended up there. It's not just, it's not a random happenstance. I will leave you with this thought, and that is, this is not just a criminal justice question. This is true throughout, democratic governance. Whenever we're talking about complicated, hard questions, in a democracy, we're always interested in how much do we get the public involved, how much do we rely on expertise, how do we trade off expertise and popular accountability. And I think this is the sort of compromise between those values that we've come to in criminal justice that I think makes a lot of sense. So with that, I will
I want to spend a few moments with you this afternoon talking about macro litigation, systems litigation, and in this case, indigent defense systems litigation. This kind of litigation drives people like Norm Lefstein and Steve Bright nuts, because it takes so damn long and it is so damn time consuming, and the courts know right now that there is ineffective assistance of counsel going on right now. Okay? In fact, all three branches of government in Missouri have known for some time now that Missouri is operating in unconstitutional indigent defense system. And I was talking with Norm last night. He said, why are we having a 3-month conversation to figure out what to do here? It is maddening. I don't want to justify it or excuse it, but I do want to spend a few moments trying to explain it. For most of my adult professional life, that's what I've done, is systems litigation, whether it is school systems or mental health institutions or prison systems or foster care systems or juvenile detention systems. And in every one of these systems cases, there's a pattern. We don't go in until we've studied it exhaustively. We don't go in until it's clear to everybody involved that these systems are operating unconstitutionally in violation of the 8th Amendment or the Due Process Clause or whatever, or applicable federal statute. So everybody around knows that this is an appalling situation. Okay? And inevitably you must, and you should, and it's good practice to go in and speak to the decision makers, the state decision makers, and say, here it is. It's been studied here, and it's been studied there, and it's been studied here. And would you please move in this direction? Okay. And inevitably the response is, no, we have no intention whatever of moving in that direction. We're in control of this system, you're not, and we're not moving in that direction. And then, beginning with when I graduated from this law school in the 60s, the 70s, what we would do is we would run off into federal court. Okay? Because the federal courts loved us back then. Okay? And we would say to an unelected, lifetime appointee federal judge, this is an appalling situation. And I want relief, and I want relief now. Okay? And if we had done our homework in public education so that we could make sure that when we were spending that judge's capital, the public could go with him, okay, we could get some pretty good relief. Unfortunately, as Justice Brennan predicted in a remarkable little article in the Harvard Law Review in 1977, we were about to lose that avenue. We were going to lose it two ways. The first way was procedural in the abstention doctrine, Younger versus Harris. So you got to abstain for states. You know, there were all kinds of federal avoidance doctrines to keep us away from enforcing the Bill of Rights in the United States Constitution and other applicable federal statutes, and keep us away from enforcing those in federal court. And then, of course, the bad news was that maybe we didn't want to go into federal court anyway because we were going to wind up losing because the federal judiciary, the makeup of the federal judiciary changed significantly during that period of time. There's no question in my mind that these challenges to indigent defense systems should be brought into federal courts of this country if they were open and available and provided a likely avenue of success. But increasingly, as Justice Brennan urged us, we've been turning to state courts and state constitutions, okay? Because those state constitutions provide avenues of relief which can be higher, a higher standard than the analogous federal counterpart, and those decisions are unreviewable by the federal courts because if based squarely and adequately on independent state constitutional doctrines. And so now we're not appearing in front of lifetime appointees, independent, not elected judges, but we're appearing in front of courts and we're telling them in one manner or another, whether it's schools or mental institutions or prisons or foster care or juvenile detention or indigent defense systems, that you need to have a discussion with the people who provide the funding for your budget. That would include, of course, your salary. Okay? And you need to be involved in discussions with them where this class of people, who are some of the most despised people in our society, this class of people are getting more resources, okay, to assert defenses in our criminal justice system. That involves a whole different set of considerations that we had never really, not to that degree, we had never to that degree had to think through this relationship, this really dynamic relationship that goes on between the state Supreme Courts and their legislatures. And some fairly creative stuff, I think, has been done. Justice Brennan, in his 1977 article, pointed to a number, he picked out 5 or 6 different states where the state court had said, state's highest Supreme Court, or highest court, the Supreme Court in that state had said, well, I know that's how. it's interpreted in the federal courts. But this is New Jersey, and it means more to us in New Jersey than that. I practiced law for 30 years in Florida and watched that court develop a remarkable, rich, robust jurisprudence of inherent power to protect the court's ability to adjudicate the cases that come in front of it. Okay? And they had to be in this rather dynamic relationship with the Florida legislature. Now, if we really step back for a minute and look at what's happened since 1963 and the United States Supreme Court's decision in Gideon, what's happened here in Missouri, although it's 49 out of 50 right now, is not terribly unusual. This is with very few, you've heard Norm talk and Steve, they've got a good national expertise. With very few exceptions, this kind of situation exists in every state. Okay? In fact, you could argue that there's been a revival of the interposition theory with respect to Gideon versus Wainwright. Interposition, you will remember, is the theory that states have the right to interpose their authority to protect their citizens from the unconstitutional actions of the federal government. Well, we're dealing with not only an unfunded federal mandate, this is an unfunded federal judicial mandate from 9 unelected people. Okay? So what do we do about this statewide, this reaction to Gideon in the states? The Florida Supreme Court at one time, in one of the cases in the 90s, appointed a special master and took testimony. I want to figure out what's the formula. How do they decide how much the prosecution gets and how much the defense gets? And they had a wonderful trial judge who I've tried a lot of cases in front of now in Tampa, Judge Cheatman. He took testimony and he wouldn't stop. He'd conduct his own cross-examination. He got to the bottom of it. The formula was this. They would figure out how much they were going to give the prosecutor, and they'd divide that in half. And that's how much the public defender got. Okay? Well, that was a wonderful little insight for all of us who working on that system. But of course, that helped change it for a little while. Well, another principle you have to live with in systems litigation is that when you finally do get the court to move them from here to there, they'll do it for a while. Okay? But as soon as they think you're not looking, okay, it's back here. Okay? And you got to come back. Okay? Which means that you got to preserve the capital of that institution that gave you that victory in the first place. Okay? That's very important that they come out of that intact and ready for the next time that it happens, 5, 6 years, whatever it is, down the line. The Florida Supreme Court came up with this theory. They're sitting there dealing with an increasingly conservative legislature, which has less and less what should I say? It's the notion that we're going to adequately fund this indigent defense system is getting less and less support in the legislature. And there was another crisis in the 90s, and the court deals with it, I think, in a wonderful way. They have a long section in the opinion about separation of powers and recognition that here in the Florida Supreme Court, we don't appropriate. That's over here in the legislature. We're not in charge of appropriation. That's the legislature. So let's get that straight right now. We understand where we stand in the order of things. But we are in charge of the justice system. That's our primary responsibility. And we are not going to operate, we're going to not oversee an unconstitutional justice system. It's not going to happen. So here's what we're going to do. Okay. We're going to ask the private bar to come in for just a short period of time here. The legislature is going to be meeting in the spring. and see if you can't help us a little bit. It's not going to solve the whole problem, but it'll help us a little bit. And we're going to give the legislature a chance to do the right thing. And but if they can't find it within themselves, to do the right thing, then because we're in charge of the justice system, we're not going to let it go forward. Okay? And ultimately, these cases are not going to be assigned to public defenders, and ultimately, in an appropriate time, we will entertain motions, habeas motions, and order discharge. Okay? The defendant will be discharged. Okay? And that's in the language of the case. That was 15, 16 years ago, I think. And the legislature stepped up, did the right thing, and they didn't do all the right thing, but they did enough of the right thing that the crisis was averted. We've had that happen several times since. I think Wayne Logan's going to talk to you later on about they're being asked once again to step up to the bar. And we can't even tell if they're going to take the case or not. They've held it and held it and held it. It's a great case. Norm testified in it. It's got great facts, great trial judge, great expert testimony, great public defender, great lawyer representing the public defender. Everything's there. We're going to hand it to them on a silver platter. We don't know if they got the guts to stand up to it. We're going to find out if that rich, robust tradition of the Florida Supreme Court is going to work or not, okay? Or whether we've lost that. I wrote a little bit in the paper that I submitted about my concern with the Massachusetts experience, because I saw there where that court, and this was right after they'd done the gay marriage case, and all hell had broken loose in the Massachusetts legislature when the Massachusetts Supreme Court ruled in favor of gay marriage. And then in a very short period of time, like June is filed, July is argued release. And at that time, the governor very adroitly said, well, Massachusetts Supreme Judicial Court wants to release violent felons onto the streets of our cities. And the court pulled back and started to sign lawyers, et cetera, et cetera. It's an ugly thing to watch a court crawl back into chambers. Okay? It's not pretty. Okay? Because that problem's going to come back. Eventually the problem got resolved, and resolved very well in Massachusetts. But 6 years from now, 5 years from now, we need to go back to that same institution. Okay? And its capital is precious to us right now. I would suggest, that these same considerations are applicable to what you're going through in Missouri. I can't say enough about the work that Kat and Peter and Marty and Doug Copeland and the Missouri Bar have done. I mean, it's remarkable. The idea that public defenders would go over to the legislature with this bill about caseload maximums and withdrawal, and that they'd get a unanimous vote out of the Senate over the opposition of the prosecutors, and a virtually unanimous vote out of the House is absolutely remarkable. And get the statute. And yes, the governor vetoed it, and as Kat said, some of his reasons were good. But what you got out of that was a governor's commitment and his veto message. This, first of all, acknowledgement. This is a resource problem. Okay? That's big. Okay? Secondly, I'm committing myself to solve the resource problem. Okay? So we need to take him up on that. Okay? He's got a public commitment. And that paves the way, I think, a lot for the Missouri Supreme Court's decision in December. And the political cover that the court got from that hard work to get that statute is remarkable, because it's going to be, here's a court that's under, you all know a lot more about it than I do, but this court is under enormous attack right now. My understanding is they're raising tons of money to go after the Missouri plan, this court, et cetera, et cetera, et cetera. And I talked to Kat today. I said, anybody? Have you heard anybody say anything? Any prosecutor, any legislator, is anybody calling this court out for what it did in December? Not, we know of nothing. Kat knows of nothing that anybody has said. And we wind up with a unanimous Missouri Supreme Court opinion. And you know, enormous credit has to be given, by the way, to graduate of this law school, Antoine Smith and Shook, Hardy, and Bacon, who did all the work on that case. It's a remarkable and totally unexpected result. I think the fact that the political work had been done to protect that court's capital was really important. And although the 3-month thing bothers me as much as it bothers Norm, at least it has engendered these little discussions going on around the state. You know, what we're going to do about this. And the number one item is, well, does this guy really need to go to prison? Okay. That may engender some more discussion around the state about the inputs into this system. You know, you all are the outputs, okay? But the inputs, I mean, how many of these nonviolent people is it, you know, that we're going to continue in Missouri and elsewhere around this country, unique among industrialized nations, not even industrialized, among nations in the world, that we're going to imprison this huge number or percentage of our population. And now that the states are broke, isn't this the time that we ought to start considering whether or not we want to put all the resources of the prosecution, all the resources of the public defender, and all the resources of the prison system on all these nonviolent offenders? Okay? So that having that discussion occur is, I mean, anytime you get a real public discussion going around this issue of indigent defense and the costs that are involved, decriminalization and the extent and the overutilization of imprisonment inevitably bubbles up. Where will that go? I don't know, but I think there are going to be a whole bunch of these little discussions going on all around the state, and I have some optimism about it. It may be. I'm an optimist, so you know I'm not going to change. I think there's some shot at that. Again, the key in Missouri is it's an old decision, Wolf versus Ruddy. And again, right at the core of that holding of Wolf versus Ruddy was they can order discharge if this matter can't otherwise be resolved. And the fact that judicial history is there gives, I think, Missouri a great shot at this problem. I think we're going to learn an awful lot in the next 6 months. All right.
Okay, I'm supposed to comment on what I've heard. It's been some variety. And it seems to me, as I understand it, Missouri is in a crisis. I think everybody agrees. It can't be much worse than it is here. It's a fair estimation that you're saying of what's happening to criminal defendants, what's happening to indigent defense. And the issue is, how do you get somewhere out of this? And, you know, one possibility is litigation, and I can't speak much to that. I don't know much about it. And I don't have any answers. But I do have some thoughts from my experience and from what we've gone through in North Carolina. And I want to start some discussion and maybe leave some thoughts behind, and that's all I can do when I go home to someplace warmer. I don't think North Carolina was ever quite as bad as it is here now, but it was in pretty bad shape in the early 90s. Norm, you were there, you looked at the system. We had judges setting fees, cutting fees. We had public defender offices struggling, very few of them. It was all state funding, which was good. It wasn't county funding, but it wasn't in very good shape. And then in the mid-1990s, there was a legislative study commission that looked at the problem of indigent defense. And one of the approaches to the study commission was, we're spending millions of dollars. Nobody is deciding how we're spending it. I mean, the legislature allocates it, and then you get all these judges making decisions, and nobody's looking at this as a budget. You know, we don't run businesses this way. We don't run any other state department this way. Say, here, you people take a bunch of money and decide who to give it to or who not to give it to, and it just doesn't make any sense. I don't think North Carolina legislators aren't a lot different than Missouri legislators. You know, there's sometimes we're more liberal, more conservative at times, but you know, it's not exactly like we took UNC Chapel Hill and set them over in Raleigh and put them in the state senate chamber. I mean, their people were primarily a rural state. There's a lot of power from down east, which is the most conservative part of the state. But they responded to that. And they thought, you know, there's something wrong with us shoving all this money in and not knowing who's spending it and nobody having control over it. So we created something called the Indigent Defense Commission. And I think, you know, we've had it for 14 years now. We're better off than Georgia. We don't have a mule driver or whoever running it. We actually, our first director of the Indigent Defense Services was our appellate defender, who had been a former public defender. And we've always managed to keep a fairly significant, what I consider our people, in charge of the commission, so that you know, concern for the clients is at the forefront. Now, we're not there. I mean, Norm was saying he talked to our executive director last week, and we've got problems, and we're trying to figure out how to do it, but I was appointed to the commission last year, and I'm just learning what we're doing, but I can tell you that we're sitting there, and we're really thinking two thoughts. How can we improve defense for the indigent defendants in our jurisdiction? That's one. And the other one is, how can we spend the public's money wisely? Because unfortunately, once you get in this position, you inevitably become a bureaucrat. And, you know, I've now found myself looking at Norm as the revolutionary, and I'm the bureaucrat. It's a far change. But that's, it is a start to a system, and the question is, how do we begin to move Missouri towards, essentially, it's not only a system that's constitutional, which is required, but one that's rational. I mean, you think about this. This is such an irrational way of doing business. To shove the money there, to overload people there. And I have a couple of thoughts. Sean, you said there were 18 exonerees. Yes. We do not go near the legislature without one or more of our exonerees sitting in the front row. Because as far as we're concerned, the money we're collecting is not to defend guilty people. It is to defend these folks. That by underfunding defense spending, we are putting those innocent people, and countless knows how many other, in prison. And part of that is changing the public discussion about that. And so that is, and, you know, frankly, our exonerees are very happy to do that because they all suffered from it. They know what happened. They know we got a guy who was declared innocent last week from our new Innocence Commission. There was physical evidence exonerating him that existed, what was it, 11 years ago around when he was convicted. His lawyer didn't know to ask for it. I mean, you know, there was SBI bench notes that could have shown at the time that there was no blood on his truck, that the only physical evidence there was a lie, and he didn't have an attorney who knew how to ask for it. So you begin to when you talk to a legislature, you're saying, you know, you spent hundreds of thousands of dollars to put this innocent guy in prison, to let a guilty guy go free, and frankly, the reason you did that is you weren't willing to spend for a decent attorney. That's an irrational, if you think it's $30,000 a year to keep him in prison every year, and you're spending that money, and what we're telling you is that if you give us this money, we will spend it wisely, and we will prevent these mistakes from happening. Now, obviously, we don't judge who's guilty or innocent before we defend our clients. And obviously, that we defend everybody who comes in front of us. But what we're doing is the only way the system can winnow out the innocent, to any degree, and I'm sure we can't do it all the time, is to have the resources to do it. We can't do it when somebody's got 300 cases and can't talk to their client before they come to court. You can't know that. So that's one thing we did. Something else that, you know, families of exonerees, and getting them to the press is important. Something else that, Kat, you talked about the bar participation, and Sean, you talked about bringing private lawyers back because of conflict. I was born and raised a public defender. I mean, I started at D.C. This is where my heart is. I think 15 years ago, if somebody had asked me, I would have said, give everybody a public defender. We don't need private lawyers. I've come to the conclusion that I was wrong. And I was wrong for a number of reasons. In North Carolina, our tradition of criminal defense is a small-town lawyer who does plaintiff's work and does criminal work. And that's continued quite a bit. I mean, we have a fairly significant amount of our criminal defense is still done that way. We have public defender offices scattered around the state. I think 9 or 10 of them now around the state. And in our big cities, we have public defender offices. But all conflicts are handled by assigned lawyers. And in many of our jurisdictions, it's all done by assigned lawyers in there. And that's made a really big difference. Because what I was thinking about for you is how, you know, I hope the lawsuits work. I mean, bless them, I hope the Missouri, you know, our problem is that our judges get elected and they're more vulnerable to political pressure than our legislators. And, you know, and I hope that works. But if it doesn't, how do you turn the legislature? How do you get them? And that makes me think of who are your constituents. You know, it's true. You're not going to get anywhere getting up there and saying, you know, you've got to make sure you've got to be fair to this guilty rapist or guilty murderer. I mean, you know, unless you can get Steve to talk, it's not going to work. You know, then it would work. But you know, they don't care. The North Carolina legislators don't care. They don't. You know, if somebody's guilty, if somebody does this stuff, you know, they're lucky that we don't kill them tomorrow. I mean, so they're not going to care about that. So how do you get them to do that? Well, when we are going for money, the people who are constituents in that respect are, one, the potentially innocent people. Two, it's the lawyers. It's the lawyers who are going to get paid, or who will not get paid if they won't fund the indigent defense system. So this conservative legislator from Wayne County, North Carolina, whose best buddy in the country club is a lawyer who does some indigent defense, who goes to him and says, if you don't raise, you know, $10 an hour for indigent defense, I'm not going to be able to make my office overhead. And it changes the dynamic. They'll do it for their buddies. They won't do it for, and I don't think they'll do it for public defenders, because they see public defenders as the other. They're the young kids who chose to do this, and there's something wrong. So one of the it's true. I mean, as a public defender, I always tell my students, you've got to be a little warped to do this. I've always been proud of that. And I think it does make a difference if you can broaden that. Now, y'all have had some success going to the bar and having them do that. Who lobbies for you?
And Marty.
Well,
and the
one
bar.
of the things
Actually,
is-
we've had someone from the bar that has been
Yeah.
a big key in that as well.
And having people from the bar lobby, really getting a wider group of lawyers. This is a lawyer's issue. And it is those of you out there who are going to be lawyers in Missouri, this ought to be your issue. These are your brethren and sistren who are representing these folks and deserve to be treated decently and to be paid decently. And it ought to be a much wider bar issue. And, you know, we've been lucky in North Carolina because our criminal... Do you have an organized criminal defense bar?
Yes, Missouri Association for Criminal Defense.
Do they do any indigent work?
They do some contract work.
Okay, but that's it. Do they help lobby on this?
They have this year. They have been...
Okay, I mean, to me, that's so important, is to get the wider bar involved in different ways. Our criminal defense lawyers, both public defenders and other lawyers, are joined together with our tort lawyers. So we get that lobbying club, and that helps in there. And so you can pull things in. You know, one thing that scares me is I'm not sure we're bipartisan. I mean, you know, it does mean you've got to look for allies where you normally wouldn't get allies. Innocence you know, preventing the conviction of innocence is a nonpartisan or bipartisan issue. In North Carolina, the whole innocence movement was led by a conservative Chief Justice Lake. He was the biggest actor in that. He was convincing in his a young woman named Chris Muma, who's also a Republican. They led the movement for it. So all of our stuff that has, you know, and we got a broad discovery law. We got a broad discovery law because to help innocent people. So all of that is exceptionally important in this. And I was looking at some of the facts we've come out of. And again, this is not nirvana. We're further along, but in 1996, the allocation for indigent defense services in North Carolina was $42 million. In fiscal year 08, it was $113 million. Now, you know, a lot of that is caseload wise. And it's, you know, I'm not sure how much more per case were spent, but we've been able to get the money in there, kind of using these strategies. Maybe there'll be different strategies working here, but I guess what I come back to is that essentially this is a political issue. That, you know, if you're talking about the court and you're using the Constitution, you're using them as a political bludgeon, because eventually the legislature is going to have to come out with the money. What happened in Florida is you got the court bludgeoning, and then before the court went bad, you got some good response out of the legislature. You're hoping that you can use it again. I mean, you know, it keeps coming back and forth, but eventually they've got to decide to spend the money, and that's really, I think, when we have the discussion, is how do you move it? I mean, it is unconstitutional, but frankly, that doesn't matter much to these folks. Though I will tell you, during the last budget year, when our executive director went to our legislator, and they were cutting like crazy all over, and we got cut a little bit, but not much. And our legislature accepted the argument that we have no choice but to provide this money. We simply don't have any choice. The other programs you had, as was said this morning, they're not constitutionally mandated. We've got it. It may not be fair, but we've got to do it. And then the other part is, I think we're at the place now where our legislature trusts that we're using the money well, that we're not wasting it for them, that we, you know, and that's important too. So that's just some, you know, having been asked to comment, that's just some thoughts I have on this. Thank you.
I just want to follow up a couple of things that Rich raised. Getting the private bar involved is absolutely critical. I think one of the successes, and Norm and I talked about after the first panel, Wisconsin is not without problems as well, but they have consistently had private bar involvement, and it helps not only in advocating in front of the legislature, but also you don't have all the inbreeding where you just have public defenders. You get innovations, you get some incredibly good private criminal defense lawyers who stay engaged in the criminal justice system. So it is critical that you do have private bar involvement for all sorts of reasons. Second thing, and this kind of is a follow-up to one of the points that we talked a little bit about this morning, when I was interesting when Kat said that they had the Public Defender's Office in Missouri had 89,000 cases in 2004. This year they had 83,000 cases. That's 6,000 less cases. My guess is overall the system went up even more. Where did those cases go to? Well, those are the cases I was talking about in terms of raising the eligibility requirement or finding public defenders going in arguing against the eligibility of certain clients. Those are the people who then are left without any lawyer at all, or left with a really under-resourced lawyer. So that's, I think Kat is exactly right. Fixing the public defender system is a separate question from fixing the delivery of indigent defense services in any jurisdiction. And there's a lot more I could say, but I want to give, where did Adam go? I want to give everybody else a chance, if they have questions, to direct them to any of the panelists, or if any of the other presenters want to make a comment. Anybody have a question?
It's like a law school classroom in that.
Yeah, there you
I
go.
have a
Zach.
question. I used to be a public defender in the state system. There's sort of this attitude of if you can't handle it, then you're not tough enough. You know, I mean, if you bitch about your caseload, if you bitch about the money, then there's this rite of passage, this badge of honor that they carry, or that we carry. If you would make noise, if you would say, you know what, Judge, I can't do this, I have to withdraw, the eyes of management get on you. And then the problem is focused upon what's wrong with that attorney. Not what's wrong with the office, but what's wrong with that attorney. And I think maybe that's one of the problems as well, is that people are scared to really sort of vocalize what the problems might be.
I don't think it's fair to expect the line public defenders to take the lead on this. I think it's got to come from the top. It's got to come from leadership, not public defender leadership generally, but the statewide bar on this. And I think that's a heavy burden to put on somebody who's getting a salary.
Norm?
Well, it is a heavy burden on the line attorney. The rules of professional conduct are very clear that ultimately, if there is an unreasonable judgment by the supervisor to the effect that you don't have an unreasonable caseload, then the individual attorney does have an ethical duty to be forthcoming about it. And I've always recognized that that's a whole lot to ask of an individual lawyer, which is why I do think it has to come from above. Moreover, I know of instances where lawyers have complained about their caseload, and the response of management has been, and it's absolutely inappropriate, particularly when the caseload is totally unreasonable, that we're going to fire you if you don't handle this caseload. There is a right not to be fired under employment law principles in that situation. And the head of the program that doesn't back up the individual lawyer in that case has recourse against the head of that office. And it's an area that I've looked into for that very reason, which I'm going to write about later this year.
He's been writing this for a while. We're waiting for it to come out.
He's got a lot to write. Come on.
At the end of this year.
Show me the
Anthony
book.
keeps changing.
Conversely, I mean, there's a very clear duty on the head of the program. I mean, there ought to be, in a program that has the resources, there ought to be interaction where management knows what those caseloads are, is monitoring them on a very regular basis, and a meeting of the minds about what is reasonable and what isn't. And that's what's missing here. I wanted to say one other very quick thing. You talk about electing public defenders. Because I'm very old and I still remember it, San Francisco is the only city and place in California that elects its public defender. Many, many years ago, the former elected public defender in San Francisco came out in favor of the death penalty as a way of cultivating his political...
Lowers the caseload.
So not offended.
Yeah.
Well, what do you do if your management says, we're working on it?
For 5 years.
7 years, 8 years? We're working on it.
Well, that's not a satisfactory answer.
Tell him Norm says it's not a satisfactory answer.
Okay, can I respond to this?
Sure.
As the one that's saying we're working on it, let me just say. One of the challenges, one of the benefits that we have of being a statewide system is that we do have more big picture data than a lot of other places coming in. But this is also presents a challenge because we have the lawyers who've been and experienced what it is to do a case right and who know how overloaded they are and who are ready to, you know, in Norm's style, pull the plug, everybody go on strike, let's pull this to an end immediately. And at the same time, we have many lawyers who have never practiced any other way than triage. You can ask them any day of the week, how are you doing? Do you need more, you know, how's your caseload? And they're saying, I'm fine. I'm fine. I don't know why management is making this big deal about caseload. I'm doing great. You know, we're good. And so what you have is, when you have the one lawyer who pulls the plug, the judge says to management, okay, bring in somebody else from another office. And so then you have a hearing about everybody's caseload in every office, and those other lawyers who don't know better, it's not that they're not good lawyers, it's that they don't know better, when they're asked that question, are saying, well, no, actually, I'm not that overloaded.
This is an educational process.
Right, and so that's one of the reasons it's a long.
out there like that.
Or they don't want to be fired, or
Right.
they don't want people to look at them as, you know, I'm just trying to do my job and not get in trouble.
Yeah, I mean, I think it's very hard in any situation for one person to stand up. I mean, and when that happens, when it's the one person who stands up, it's like a whistleblower any place. Everyone goes, oh, it's so-and-so, you know. They're the kooky one. They're the one that's always complaining. They're the one that nobody can get along with. So that person becomes somewhat isolated, and the rest of the staff doesn't really want to join in that. So people have to organize in some way, because otherwise you get ostracized and you don't get the support from the management. So people have to have a conversation among themselves so that it isn't just one person. And yeah, you're going to go to your supervisor, but then if you don't get that response, that you don't get the backup from the supervisor, there have to be more than one person. And we have to talk about it together, decide when, who, what judge, right? Some judge is going to be a heck of a lot more sympathetic to somebody saying, I withdraw. You know who the judges are that you can talk to, and you know who the judges are that you can't talk to. And don't think that when they brought the litigation in Florida, they didn't think about what judge they were going in front of, because they sure as heck did. So this has to be something that people talk about and think about and plan.
I want to make 2 points. The first is, we've talked about the line public defenders, and we've talked about central administration. In my view, one of the key actors in this whole process, if you're going to have a successful system, is you have to have office supervisors, office managers who are very good lawyers with courage and credibility, both with the local judges and with central administration, so that they can help train their individual lawyers to come to them and say, when your caseloads get to the point where you can't do the kind of job we've trained you to do, you've got to let me know, and I'm not going to assign any more cases to you. And you also have to have the backbone and ability to get rid of the slug lawyers who are in your office. We had a lawyer in our office. We had one day, it was the Midnight Massacre, where we fired 3 lawyers. Guess what? They were the 3 lawyers who handled the most cases in our office, but they were handling them incompetently. I went into one of the young lawyers' office. I said, you did a jury trial yesterday. You were back here at 11 o'clock. He goes, yeah, it was a quick trial. I go, damn straight it was a quick trial. It was 2 hours. What did you do? Let me see your file. He didn't have a police report in his file. He didn't have anything in his file. He went in there, and the judge actually called me, because we had some really good judges. He said, this guy is totally incompetent. So he handled the most cases in our office. Nonetheless, we got rid of him. That sent a message to the other lawyers in the office. It's not the number of cases that you handle. It's how well are you doing them. Okay? Completely separate point. And this is follow-up on accountability. Accountability, part of what I hear Rich saying is, if the public defender office is going to get money from the legislature, it's got to be able to go there and demonstrate that the money is being used wisely. And a lot of that involves the kind of PR campaign that Kat Kelly is now orchestrating. And that is getting the state bar folks behind you so that you can go in there, and so they are confident that money is just not being frittered away, because they don't want to fritter it away, particularly on rapists and murderers. When you can combine both credibility and the theme that we're also making sure that the system operates correctly and accurately so we don't send innocent people to jail, then you can get conservative people in the legislature to buy into the notion that, okay, we'll give you money. And the reason that is, I mean, we got a serious problem in Missouri and lots of other states. The problem with the term limits means that a lot of experienced lawmakers who understand the way the criminal justice system works don't stick around. The second part of it is happening in Missouri and many other states. Too few lawyers are now going into the legislature. So we don't have enough people who understand the way the system really works, and it's harder to deliver the message you're trying to deliver. So we all have to work together to make that happen, because otherwise it's going to be an extremely tough sell.
You got a question back there?
Someone spoke to this slightly in the first panel. I don't know who was here, but it wasn't. But I'm wondering, the only system I really have experience in is very small in Wisconsin where it's unionized. And I was wondering if any of you, your states are also unionized, or speak to how being in a union as a public defender or a line public defender could help in some of those situations where people are feeling pressure and feeling like they can't step up and really say, I just had too high of a caseload.
That's a dirty word.
In New York, the Legal Aid Society, which is not, the Legal Aid Society lawyers are not public defenders. They are part of a not-for-profit organization that contracts with the city, but the lawyers are unionized. They're part of a union. And I think it cuts both ways. I think it cuts both ways.
I will absolutely say, because I led the fight against the union, because we had a good public defender's office, the union came in saying all the Wisconsin public defenders were part of the state association, but we didn't have to be part of the union. And they came in and they said, we want to make you part of the union with the attorney generals, with the DNR lawyers and everything else. And I said, you know, I think that's a horrible idea. We've got a really good salary structure. We've got good lawyers. We've got independents. And we had the three people who were the three highest caseload people in the office. As the supervisor, I would have never been able to get rid of those three slug lawyers if we had the union. I lost. I lost that fight. I was the chief staff attorney because I was part of supervision. And I warned them, I said, you know what will come with the union? You're going to have time clocks. You're going to have all the things that we don't have. Well, ask the lawyers who are still in now compared to where it was before the union. I'm a pro-union person, but not for criminal defense lawyers.
I'll add one other thing. When I think about who on the Indigent Defense Commission are my constituents, and I said, you know, I think we use the lawyers to go to the legislature. If we do our job right, they get paid better. But the constituents to me, for all of us who are concerned about indigent defense, are the clients, first of all, that the poor people will have no choice but to come to us or our systems. And secondly, the people who pay the bills, pay the money, the public. And I do think that we have obligations to those too. I think paying lawyers well is a necessary part of that, but they should not be the prime beneficiaries of this.
As a card-carrying member of the UAW, I want to say there's a difference between putting together cars on an assembly line and being a professional that administers justice. I was hired to do a Spangenberg-like study on the Illinois system in the late 1990s. And part of their problem in their capital defense unit, and the reason they have so many exonerations in Illinois after the fact, discovered by people from outside the system, is they have a unionized system. And based on seniority alone, you can bump into that capital unit for the pay difference. And so they had people doing capital cases you would never, ever hire if you had a choice as an office manager. Cook County.
Yeah, and Cook County has been unionized for years, has enormous caseloads. It's no protection. On the other hand, Seattle is unionized, and I haven't seen that it makes much difference. I've talked to both management and the lawyers, and it doesn't matter.
Although I think the parity concept would go further.
Which is, would it help you be brave? It might help you be braver, because you might feel that you'd be protected in a certain way so that you couldn't be fired for speaking out. When we say that it cuts both ways, it also means that, just as with the schools and the police, you have less ability to move people out who should be there, you know, to make those kinds of decisions. So that's why I can say it cuts both ways. I don't know how much that happens anyway, you know, frankly. So.
Can I have one closing comment? I just want to say that since we started this process, we did receive in 2006, I guess is when we started it. In 2007, we received an extra $1 million or $2 million for salary money for the lawyers. We received an extra, the following year, $1.15 million for contracting case overload. Last year, for the first time, we got 12 new lawyers. It's the first time in almost a decade that we've actually gotten lawyers and money to fully fund payroll. There's a thought. And this year, when every other department of state government is facing cuts because the state's $340 or $50 million in debt, the governor recommended an additional $2 million in new money for us that so far has come out of the House Appropriations Committee. Whether we can keep it through the legislature is still to be seen. But there is movement, at least in a good direction. The other really good thing in terms of those conversations continuing to happen is there is a Missouri Bar Justice Task Force that is currently in place that, I don't know if Joe Mosley is here, I think he may have had to leave, who was chairing it. But it's prosecutors and defenders and private attorneys, many of whom were former prosecutors or defenders, and they have made some recommendations to infractionalize a lot of misdemeanor cases and have been meeting with legislators and the Chief Justice, and it looks like a bill may actually be filed this year to try and make some difference there. So there is movement. It's glacial, I understand that, but it is movement in the right direction. So.
I have a question that goes to the structure of indigent defense systems and interrelates to the issue of getting private lawyers involved in indigent defense. And I think it's, as far as I can tell, an anomaly in Missouri. There might be a few other places that basically change the ethics rules for conflicts when it comes to the public defender system. And so, unlike law firms throughout the state of Missouri, and unlike public defender systems in many states, in Missouri you could have somebody that is in St. Louis County doing conflict cases in the city of St. Louis. You know, there's certain steps taken to try to wall people off, but they're all part of the same entity. And I guess so the question for everybody there is, in terms of kind of systemic approaches, your reactions to having different set of ethics rules, essentially, for the public defender system. Ethics rules that are, I would contend, aimed at trying to reduce the expense, because I don't think there's any other rationale for that separate rule. But maybe there is a rationale, and I just throw it open to everybody.
I would say no, there's no other rationale. It is entirely expense. We ran the numbers not too long ago to see what it would cost to contract out all of our conflict cases, and it came to right, I can't remember if that was the $3.5 million or the $8 million, but anyway, millions to do that, which we don't have. So we have just basically treated it as if each office was a separate firm for purposes of conflicts. I don't think you will find many people in the public defender system who disagree that that is a questionable determination.
And that's a real problem with the head of each office being an employee at will of the central administration, which gets to Nancy's question and your question about, you know, where do you find an administrator with the huevos to stand up for you? And if your head of your individual office doesn't have some protection from him experiencing some retaliation, then, or her experiencing retaliation for sticking up for the frontline lawyer, you know, the Jack Walsh scenario is a good example. He's facing a judge on the morning of trial he's done nothing to prepare for because of his caseload. He tells the judge, I cannot ethically do this. The judge says, do it or I'm going to hold you in contempt, and he sits there silently. And he is held in contempt, and he is ultimately disbarred. Same scenario in Jackson County. Different result. You know, the office files a petition for writ of mandamus in the Court of Appeals to protect the trial lawyers. Jack Walsh is working in a hotel in Chicago. Those two lawyers are judges in Jackson County. That's the difference between having the head of an office who has the protection to protect his or her people.
We are going to take a 15-minute break, and the last panel will start at 3:15 with some really good stuff, so please come back.